here, and you can listen and you carefully to this free webinar. Before I start, I hope you are all healthy and safe at home. And I know most of us are working from home, and I'll take this opportunity to, express my feeling and to say Ramadan Kareem to all, and may this holy month, with this holy month and this pandemic COVID-19. So today in this webinar, I want to take you to a trip to alternative dispute resolution, or ADR. What's an ADR? What are the component of an ADR? We'll come across to it in this free webinar. But before that, let me introduce myself. My name is Charles Joseph Tawk. I have a bachelor degree in law and a master's degree in human resources and training. I don't want to go through all my bio. I want to tell you that I am happy to be a member in many organizations, mainly in the Red Crescent and Cross organization, and a member of the Chartered Institute of Arbitrators. So what to expect in this half an hour free webinar? In this webinar, we will introduce ADR, Alternative Dispute Resolution. We will see what are the benefits of using ADR instead of the regular jurisdiction, and the different methods of ADR. So, in this regard, the scenario one, let us put a scenario. Imagine that you've been wronged by a supplier, or by your employer nowadays, or by a business where you are a customer. So you've correctly determined that you have, a legal claim. What are you going to do? So here we are, we don't go directly to lawyers, to the court of law. Do we have alternative dispute resolution? So I'll ask you a first question. This is a general question to everyone. So what will you do? Will you run to the courthouse to file a formal claim, to initiate a litigation, or would you like to resolve that dispute in other alternative ways? So in order to answer that simple question, I will launch a survey where you have to vote. So click which of the two answers will you choose, answer number one or answer number two. I will leave you now to vote, and then I will share the voting results with you. So I can see you are voting. Thank you for being, for interacting with me. I still have some people, they are, thinking about the answer. Okay, 7 out of 11 answered. So I will end the voting after, a few seconds. So ending the voting now, and I will share with you the results. So I'm sharing with you the results. So you've all voted. You see the result of the your answers. And let me go to the presentation. And for that, we will say that alternative dispute resolution is a common method of dispute resolution that avoids many challenges we find in litigation, so in the court of law. So this is why we call it alternative dispute resolution. But many of us, when we say alternative dispute resolution, we think that this is the right answer. We should always go to arbitration or the other dispute resolution methodology. However, this is a preference nowadays in the business concept. So in order to know what's ADR and what are the main component of ADR, so alternative dispute resolution, is a resolving dispute but outside the legal process, and the main method are three. The first one is negotiating, so negotiation. The second is mediation, and the third, arbitration. Those three main dispute resolution methods are under ADR. There are more methods and more ways for a dispute resolution, but less used, like mini trials, hybrid form of mediation arbitration, and sometimes a collaborative goal oriented processes. So what I want to focus in this webinar are the three main methods, such as negotiation, mediation, and arbitration. So what we can know more about ADR. So ADR, alternative dispute resolution, is often used to resolve dispute among businesses. So usually it is under a business concept between employees and employer, and an organization and its customers. So it is used in many types of conflict, and we want to resolve those conflict and dispute without going to the court of law. Also, ADR is the method are used, outside the courtroom, but they have a similar system, similar to the legal system, and the participation in ADR has important legal consequences. For instance, parties that have agreed by contract to be subject to binding arbitration give up their right to bring their complaint to the law. And here I want to focus on that third point. So in many contracts, we have within the contract, we have a clause or embedded in the contract saying that arbitration, it is binding. That means when you sign this type of contract, you cannot go anymore to the regular courtroom. You have to stick by the clause of the arbitration or by the clause under the ADR. So this is very important. So from now on, when you have any contract, especially in a legal contract between you and your customers or between you and your employer, you have to take care about that issue. Additionally, why we have to choose this ADR? So why we have to choose that ADR? I will launch another questionnaire, and I hope that you will fill it. So in front of you there are many questions. This is a multiple choice question, so and you can choose more than one answer. So in front of you I shared a survey. Please try to vote, select as many as you want. So getting there. Okay. People are active and voting. Okay. I will share with you as well the result. I know that you like to see the results and what are the results. So the question two is, why to choose ADR? Because simply it has many advantages and benefits. What are the advantages and benefits of the alternative dispute resolution? First, it is more flexible than the court of law. It is private and confidential, similar to many court of law, but sometimes when you have a finalize your claim in the court of law, maybe it is posted and it is there available for everyone. This is not the case for ADR. It is cost effective. It costs less than the court of law. It's less formal, and outcomes are basically agreement while in the court they are called judgment, can help you to gain new skills such as dispute prevention and resolution. So whenever you go to that type of alternative dispute resolution, you mind and as again, as Mr. Taysir Ismail, my friend, is typing here in the chat box, he is saying that it is faster, and I cannot agree. I must agree with you, Taysir. It is faster in most of the time. So this is why we have to choose ADR. So let's go again to a memory test. So the memory test will say how many main methods are available for ADR. So I will not launch the test here. I will just wait for your answer. Please type your answer in the white space under type your message in the white space, and then I can see. Taysir is typing 5. I will not reveal now the answer. I will wait for other Mr. Taysir. Pradeep 3, Fatima 5. So we are talking here about how many main methods are available for ADR. The methods available for ADR, the main methods. I know there are alternative methods. We are talking here about the main methods of ADR. So Lama is, typing 5. Most of you are saying 5. The right answer to that question, Annabelle, is saying 3. So the right answer for that question, for sure, the main common methods are 3: negotiation, mediation, and arbitration. Good answer, Rami Zaghlul. So additionally, so if we want to know about those 3 methods of ADR, let's go and dig a little bit into each of the methods. So if I want to start with the scenario 2, so you have a quality problem in one of your supplier, and then it is a good supplier. It's been a long period yet we are dealing with him, and you don't want to jeopardize that relationship. For sure, one of the thing that you have to do is go to the ADR instead of the court of law. So what are last question for you? What is the first method to use in ADR? Is it arbitration, negotiation, and mediation? Please type your answer on the down. Is it negotiation? Fatima is saying negotiation is the first step to take towards resolving that dispute. Lama is negotiation. You got it right, all of you. Yes, you've been listening carefully to me. It is not arbitration. It is not mediation. It is negotiation. Negotiation is the first step, or you must go through negotiation before, because it is, we will see what are the benefit of a negotiation before you go to the next step, which is mediation, and then the last step, which is similar a bit in the processes to the legal processes, which is arbitration. So in negotiation is a method of alternative dispute resolution, as you all know by now, that retains power to resolve the dispute to the parties involved. So here we don't have a third party. We go and to the other to the person that we have a dispute or a problem with, and then we try to negotiate with each other. So what are the benefits of this negotiation? There are many benefits of this negotiation because it is very important because it includes the potential for a speedy resolution. Sometimes it is a small problem. You don't have to go further. You don't have to dig down. It is inexpensive. So actually, when you go and you sit with the other party, it's basically up to zero in expense, and then the fact that parties participate voluntarily in this method. In addition to this is way to do alternative dispute resolution, there are as well the other step. It is mediation. Mediation is a bit in between. It's in between negotiation, and it's not a full arbitration. So mediation is a method of ADR in which party work to form a mutually acceptable agreement. But it is like negotiation. Parties in mediation does not vest authority to decide the dispute in a neutral third party. So even though there is a third party that is involved, which is called the mediator, so we still have the authority and power to decide what to do, and to decide if we want to continue to listen to that mediator and take his opinion into consideration. Instead, this authority remains with the parties themselves, who are free to terminate mediation if they believe it is not working. So it is taking a third party. That third party should be, a subject matter expert in the dispute, and then we are not obliged to really take the mediation to the opinion of the mediator if we believe it's not working for us. So often, when parties terminate mediation, they pursue another form of ADR, such as arbitration, or maybe they can go to court of law, like litigation, and so on and so forth. So why we are using, and who are the mediators, and why we are using mediation. So mediators are disputants choose their mediator because they are people, they are subject matter experts, they are trained in conflict resolution, and most of them are certified. There are bodies of certification for arbitrators and mediators. So, and it is they facilitate the agreement, they facilitate the common ground, they facilitate what do you want to reach in your dispute, and they will show you most of the goals, basically, or the common goals to reach to an agreement. So what are the benefits of mediation? The relative, it is not expensive. It reduces the cost. It is a free way to take a third-party opinion. The opposition of rule on the processes by the mediator to keep party within bounds of the process. It's confidential process. It is voluntary in nature. So, and it is a win-win outcome situation. So very important mediation, but still the last word is for both parties. And here I want to ask you a simple question. In stage, or in method one, which is negotiation, and method two, which one will you prefer more? Method one, and why? And method two, and why? Please as well type your answers in the chat space, or in the white space in the corner, down corner right. So which one would you prefer more, negotiation or mediation, and why? So I'm still waiting for your answer in the chat box. Yeah, some people are typing negotiation. Negotiation for Pradeep, because maybe he likes, to negotiate with people, and maybe he wants to, keep the authority for himself, when to decide to leave, and if he decide to accept or no. Okay, so we have, opinions. In my opinion, both are important. But if I reach to a place where I don't have any way to solve a problem, it's good to listen to a subject matter expert in order to reach a decision without, being obliged to abide by it. And the third method, which is the most known and it is the most, sophisticated, it's called arbitration. So the arbitration is also a method in ADR in which party vests authority in a third party neutral decision maker who will hear their case and issue a decision. That decision, it's called award. The decision, it is in the court of law. When it is an arbitration, courts, it is called award. However, as I mentioned previously, if it is a general arbitration, both parties, have the right to resolve arbitrators act in equivalent capacity to judges in trial, so they are like judges in the trial. For instance, they determine which evidence can be introduced, what should they hear, and what should not. So it is very important to know they are similar to judges, but they are called arbitrators. So what we can talk about arbitration. Arbitration is a, so there is a confront here. We confront each other as a process. So it is like a trial, and it will produce for sure a winner and a loser, a winner party and a loser party. Arbitration is more formal than negotiation and mediation for sure. It is, you have to go to a third party. That third party, i.e. the arbitrator, will issue a decision, and that decision, if it is a mandatory binding arbitration, you have to abide by it. And you cannot in this specific way go to the court of laws. Parties present their cases to the arbitrator by introducing evidence. It's like the court of law. And after both sides have presented their cases, the arbitrators will issue the arbitration award or the arbitration decision, or if you want to the similar terminology in the court of law, it will be the clause. So here I have to stop and tell you a little bit about the mandatory binding arbitration. And it is not mentioned clearly in this, webinar. However, I will, give you my small, idea about mandatory binding arbitration. So the mandatory binding arbitration, it should be mentioned in the contract, where both party, they have to resolve their contract dispute before an arbitrator rather than through the court system. So mandatory binding arbitration may require the party to waive specific rights, such as their ability to appeal a decision. There are also some disadvantages of mandatory arbitration to consider. You have to consider some disadvantages. What are the disadvantages of mandatory arbitration? It is, first, you cannot appeal. Second, the arbitration decision is final. There is no formal appeal process available. Even if one party feels that the outcome was unfair, unjust, or biased, they cannot appeal it like the regular court of law. However, also, arbitration has many advantages and many benefits. despite the disadvantages that I will mention later on, there are many advantages of arbitration, and you as a person, you have to see and to weigh it to see, do I have to go to arbitration, yes or no? But sometimes you are obliged. So we have to know when we read our contract, is it a contract that allows me to go to the court of law, or is it a contract that it is a mandatory binding arbitration contract? And this is what I wanted to highlight for you. So again, what are the benefits of arbitration as well? Parties can select the arbitrator with an appropriate degree of practical experience. So you can select which arbitrator you want. Arbitration is often faster than litigation in courts. For sure, some litigation will take years and years. Arbitration is a faster process for sure. Arbitration can be cheaper and more flexible. Flexibility is there, cheaper is there, but mind you, in some cases, arbitration can be very expensive. Arbitration proceedings and arbitral awards are confidential, so anything inside the court, inside the arbitration court, will stay, confidential. And then this is very important for many of the businessmen and many of the businesses. Mind you, they are really taking care of their employer branding and their image. And then finally, there are very limited avenue for appeal of an arbitral award. So when I have an award or a decision, and especially if I have this again, the mandatory binding arbitration, I cannot go elsewhere, so I have to abide by it. So now I will leave some Q&As after a few seconds. Let me but give you some disadvantages. I don't, as a researcher and as a consultant, I must give you the dark side of arbitration. So what are the disadvantages of arbitration? If arbitration is binding, both sides give up their right to an appeal, and you know by now that if it is binding or if there's a mandatory arbitration, we cannot go to the court of law. If the matter is complicated but the amount of money involved is modest, then the arbitrator fee may make arbitration very, very expensive. Sometimes, as an arbitration as a process is not that expensive, but the arbitrator is, expensive. So the fees of an arbitrator is sometimes very expensive. Rules of evidence may prevent some evidence from being considered by a judge or a jury, but an arbitrator might consider. So sometimes there are evidence that are accepted in arbitration, and there are not accepted in the court of law usually. So therefore, the discovery, legal discovery, may be limited or more limited in arbitration. So if arbitration is mandatory or required by a contract, then the party do not have a flexibility to choose the arbitration only when they both party agree to change the arbitrator. Also, this is so a little bit here, it's not that flexible. And the last disadvantage, the standard used by an arbitrator are not as clear as the standards used in the court of law. Those were my the disadvantages that I found in arbitration. It is a alternative dispute resolution. So basically, when I clarify for you the alternative dispute resolution, it's up to you as a individual, as a professional, to choose which one you want to go. And mind you that don't forget the first two steps or two methods of alternative dispute resolution, which are the negotiation and the mediation. Now, Q&As, feel free to ask some question with the remaining time, which is, I'll give you 2 to 3 minute maximum in order to ask any question regarding the subject. Thank you for being here and listening to that free webinar. So if you want to know more about a similar subject or any other subject related to training, development in any any department, you can just go to our website, and especially by now you can see our virtual learning platform that you can access to it and see our virtual learning delivery and services. So I guess no question was good. It must be clear. Thank you so much for attending this free webinar. Stay tuned with Meirc Training and Consulting free webinar. As a last gesture or surprise, I will open now the camera saying hello live to you from here. So this is me at home and saying hello to everyone. Thank you for being here. And as I told you before, stay tuned to more free webinars. Thank you so much and have a blessed weekend.
Meirc.com